Number 123, the matter of New York City asbestos litigation, Juni versus A.O. Smith Water Products. Good afternoon, counsel.
Good afternoon. Thank you, Your Honor. May I reserve 2 minutes, please?
How many?
2 minutes, please.
2, yes, you may.
Thank you, Your Honor. Each workday for 25 years, Mr. Juni went to the municipal garages.
Before you get into the whole history, I just want to clarify something up front, and I'll ask your adversary the same thing. Is either party seriously arguing that we should apply a different standard from the standard that we've set in Parker and Cornell and Schoenar in asbestos cases? In other words, either an easier standard or a more difficult standard, or any change at all from our established standard, or are we just really applying that established standard to the proof in this case?
We're totally applying the established standard from Parker, Cornell, and Schoenar to the proofs in this case. Parker was issued approximately 8 years prior to this case going to trial. The plaintiffs had years and years to study the exact language in Parker and to understand whether their case complied with and addressed the indicia of scientific expression in Parker, and then later in Cornell. Parker, 7 New York 3rd. Look at page 446. One of the scientific indicia is whether other causes of the disease have been eliminated. In this case, the trial court, in its own opinion, said repeatedly that asbestos is the only known cause, at least, for litigation purposes, but also in the scientific community, of Mr. Juni's disease, mesothelioma.
But isn't one of the particular problems in this case is that there were a number of defendants. There were and Juni, as you started to say, did a number of different things, and so what we're left with in this case is what proof there is that Ford's products caused Mr. Juni's illness.
Each day for 25 years, Mr. Juni went to work and he worked on a fleet of 500 Ford vehicles. All the products during that 25-year period, with minimal exception, were Ford products. The products during that 25-year period, the few that were not...
The vehicles were Ford vehicles. But
yes.
The products, weren't there replacement products and...
Oh, no, Your Honor. The trial judge eliminated those from the equation at the outset. This isn't that kind of a case. All the products sent to the jury were products installed by Ford, Ford brakes, Ford clutches, and non-Ford gaskets that were installed by Ford and that Mr. Juni then removed creating tremendous dust clouds of asbestos. So
we're limiting, the proof here is limited to the original parts in those vehicles?
No, all the new brakes and the used brakes were Ford equipment in this case. The new and used clutches testified to were Ford products. There was no decision in this case, either at the trial court or in the appellate division, that what we're dealing with here are non-Ford products. The trial court's decision was that, yes, you had all of this dust generated.
But I'm sorry, yes. I just need to clarify this. You're agreeing then that that has to be established, that it was Ford products that caused?
There was no dispute that what we were talking about during the case was products for which Ford was responsible.
Okay, but you're not saying that that's all that Mr. Juni worked with in the course of his employment, are you?
No, I wouldn't say that. He worked with some other products.
Okay,
but-
that's my point, is don't we have to ascertain in all the years that he worked and in all the capacities that he worked and in all the different facilities that he worked in, how much of his total exposure to asbestos came from those Ford parts? Isn't that one of the questions that we have
No,
to
Your Honor,
answer?
because if you have some idea of a total exposure to asbestos, what you have is a concurrent causation case. And you can have, this is actually one of the easiest cases possible in the asbestos litigation in terms of assigning responsibility for different manufacturers of asbestos, because usually you have, let's say, an individual who's been exposed to 20 different asbestos-containing manufactured products, and here all the clutches that were used, all the brakes that were used, and all the gaskets that were used were installed by Ford. That's undisputed in the record.
At the core, though, isn't the question for us is quantifiability. How quantifiable does a specific causation have to be in this case for us to say that Ford, of all these other users or all these other possible exposures that the plaintiff could have had, there's specific causation as to Ford. And so if that's the case, if you can't give a percentage, which you could never give in any asbestos case ever for exposure, that would be impossible for any party to be able to do that, then you're really looking at the science as to how the disease is generated, how much exposure causes disease. Let me ask this. Is there any quantifiable safe level of exposure to asbestos in the proof that you offered in this case by either side? In other words, someone said this much exposure to asbestos is safe and anything below this isn't safe.
No, Your Honor. However, there's a regulatory standard issued by OSHA, which is a 0.1 standard. So if the exposure in this case were shown by industrial hygiene studies, for instance, in this sort of work to be below 0.1, then that would be an issue, and we'd have to say, well, there's no safe exposure. But here we're talking about the Mount Sinai studies. Compressed air blowout generated asbestos concentrations of 300 times the OSHA level. The NIOSH studies generated...
Let's
yes.
not go into the 22 different epidemiological studies right now. I just want to...
That's a different issue.
I want to stay focused on this issue, though.
Yes.
So in my review of the record, there was one expert for the defendant that referred to a quantifiable level, I believe. But it was mentioned in Judge Feynman's dissent. That was the only reference I saw in the record to it outside of the testimony itself. So assuming there's no quantifiable level of a safe exposure to asbestos, then, and we can identify what it is, then we're left with purely anecdotal evidence. The anecdotal evidence was the time he spent working on it. And are we left then with the theory that visible dust constitutes significant direct proof of causation by exposure?
No, Your Honor. There's a ton of quantitative evidence in the record. One of the indicia of scientific expression in Parker, for instance, is comparison to exposures in similar studies. Mm-hmm. And the similar studies were, as I was saying, the Mount Sinai studies showing that exactly what this plaintiff did, compressed air blowout, generated asbestos levels in the air 300 times the OSHA level. There were the city NIOSH studies without compressed air showing that it was 2 to 3 times the regulatory level. Ford's own documents were massive. They showed that beveling linings, which Mr. Juni did on Ford linings from Ford vehicles generated exposure levels of 72 fibers per cc, which is 720 times above OSHA. And that means that in Mr. Juni's cubic meter of workspace, he was exposed to 72 million fibers per cubic meter.
So
And this is every day.
I understand
Yes.
the defense here to be a little bit different than it is in a standard asbestos case, that the defense here really was, through the experts, that the asbestos in the brake products had been essentially encased in resin, subjected to very high temperatures, and then high temperatures, again, not in the manufacturing, but in the use of the brakes, that, for simplification purposes, essentially rendered almost all of it not the kind of asbestos that is reported in the other studies that demonstrate a causal link between asbestos inhalation and mesothelioma. And that you may have needed one more expert, not an MD, but some sort of a researcher to rebut the evidence that these fibers are now so small that they are easily dissolved, or they've been converted to the Forsterite.
Yes.
Is there a missing piece of proof in this case regarding that defense?
No, Your Honor. First of all, this Forsterite issue goes to the use under high heat of brakes, used brakes. There were also new brakes, beveling of new Ford brakes, beveling, sanding, grinding of new Ford brakes, which generated asbestos levels in the air hundreds and hundreds of times above the OSHA level. So that has nothing to do with the used brakes. There are clutches, new clutches and used clutches, which has nothing to do with the Forsterite issue. And then there are all the gaskets coming out of Ford vehicles that Ford installed, for which Ford is
I
responsible.
thought there was proof that some asbestos didn't actually convert, even though it was part of the
Yes,
brakes.
and then when we go to the used brakes itself, the level shown through electron microscopy was 30% of the asbestos still remained in the used brakes. But even if it was 1 to 3% asbestos, it's kind of a red herring of an issue, because the industrial hygiene studies showed repeatedly that what the brake worker is actually exposed to are levels of asbestos fibers in the air hundreds of times above the regulatory limit. Now, I understand that, for instance, in Parker, you say that the regulatory standards are not proof of causation, and there's no dispute about that. However, regulatory standards and violation of regulatory standards several hundred times above the standard goes to the viability of the foundation, the creation of the foundation for the opinion. Visible dust, that issue is a separate issue that parallels what happened in Sean R., where this court in Sean R. said that sensory thresholds are a viable alternative. They're a proxy to actual impossible to do precise measurements. And so if you've shown through your expert testimony that exposure to a sensory threshold puts you over the regulatory limit and exposes you to a substantial risk of injury, then you've gone a long way toward establishing your foundation for the causation
Judge, could I
opinion.
ask one question?
Yes.
I know we're over.
Yes, Your Honor.
One of the issues that comes up is the standard of review by which we're to look at the jury verdict here. There's been some argument that the abuse of discretion standard, I believe the defendant has argued, should apply here. And the other side of the coin is that 4404 standard should apply. You want to address that?
Well, this is a sufficiency case. The question is, the standard is whether the jury's verdict was utterly irrational. That's the standard here. The appellate division looked at that standard, accepted it, and did I think a de novo review. There was not one word of either abuse or discretion in the appellate division's decision. If you use an abuse of discretion decision and go back to the trial court's issue, there's no question that the trial court did abuse its discretion. The crux of that trial court decision was that there's no sufficient evidence of any exposure to asbestos in any of the dust over that 25-year period. Now, therefore, the trial court's theory of the case and Ford's theory of the case is that cumulative exposures that Mr. Juni sustained during the few summers prior to working on the Ford vehicles, during those few summers walking through the power plant, not even working with products, but walking through the power plant, those cumulative exposures were the sole cause of his mesothelioma. That is an incredible theory that no mainstream scientist, no physician in the world would ascribe to.
Thank you, counsel.
Thank you, Your
Counsel?
Honor.
May it please the Court, Tracy Walker on behalf of Ford Motor Company. Going to Judge Stein's question first, it is Ford's position absolutely that the Parker causation standard for toxic tort cases, as further articulated in Cornell, absolutely applies here. And the Junis did not meet that standard, as the courts below held. You asked a question about what his exposure was, and they're really two separate times when he was exposed to products. While he was working as a garage mechanic, the testimony from Mr. Juni was that the replacement parts that were purchased included Asbestos parts, Bendix parts, Kelsey Hayes parts, and other parts, and he could not recall when they were using actual Ford original equipment parts. Now, if a vehicle is a Ford vehicle and it comes in for the first time for servicing, then the first time it will have Ford parts. But then you put in a different brand parts, it's no longer Ford. And he could not recall the Ford exposure.
So how would he prove that? How would he or his expert or somebody prove what the extent of his working with Ford parts was this many years later?
He may or may not be able to prove it. In some cases, a plaintiff will have very specific recall of what he did or did not, or she did or did not work with.
But isn't that really a question of the quality of proof? I mean, he did testify that he worked with Ford parts, and he described the process, and he talked about scraping the gaskets out and doing all those things. That's exposure. It's a question of really the quality of proof, which seems to be a jury question.
It's a fundamental foundational question for the experts to render a causation opinion
Right.
under Parker.
And so unless there's a quantifiable level that's below which he would be safe, then if you show a pattern of repeated exposure, then it really comes down to how good was his proof to show that pattern of repeated exposure over a period of time.
It's not so much how good his proof was, it's whether he supplied enough information that his expert witnesses then could rely on to come up with a reliable
Well,
opinion.
could they have gone to Orange and Rockland, for example, and said, we want discovery and we'd like your records on what percentage of the parts that you ordered were Ford parts and what percentage were from other manufacturers? Is that something that would satisfy Parker's foundational requirement?
That very well could. This case is dependent on the facts. I mean, there's
No, I understand.
there's the suggestion that Ford and the courts below would put a lock on the courthouse doors for mesothelioma plaintiffs, but you have to take each case on the record that's available. And yes, in some cases, people do go
But we have to
and
be sure that there is a way, there is a theoretical way
yes.
that we're not putting that lock on the courthouse.
And people do go gather those sorts of records, and they get much more detailed testimony so that they can do estimates of exposure. For example, I read a case that wasn't from this jurisdiction cited by the plaintiffs, the Ross case, and I was just struck, again, very detailed testimony about how often the plaintiff and how much he swept each day, how many scoopfuls of this, that, and the other. And here...
Are you saying that's the minimum threshold of evidence?
The minimum threshold is from Parker, is some scientific expression. And there is no science behind the notion that exposure to visible dust, which Dr. Markowitz said was a shortcut is not science. there's no scientific study out there that says that all you need to do to show causation is to show exposure to visible dust to
That
any product.
methodology been rejected by the scientific community?
Yes, the scientific community, through the they keep doing more and more refined epidemiological studies. If this was just an open and shut case that you just have to be exposed to dust, then the scientific community wouldn't be out there studying the heck out of it to try to truly understand. And to answer your question, Judge, there is a safe level.
It's not exposure to dust. It's visible dust that's generated in the course of working with asbestos products. I thought that was the proof.
There was no description from Mr. Juni, if you read his testimony in its entirety, describing any amount of dust other than, I saw dust. In many of these other cases, you see descriptions of clouds of visible...
Well, he described it when he used to walk through the garage.
No, that was in the power plant when he was exposed to the amosite asbestos from the insulation in the power plant.
If he had used that same description for working in the garage on Ford products, would that have been enough?
I don't know that that would have been enough, but it would have advanced the ball in the direction of having some qualification.
I'm not understanding this argument. He's saying, I worked on these products have asbestos, and when I worked on them, it created dust. Some of it fell on the floor, some of it I swept up, so it's all around me.
He didn't say it was all around him, Your Honor.
But it's dust. I mean, there are certain things you take from that testimony,
Well,
no?
I guess from my position, yeah, you have to take inferences that aren't available in science to just say there's dust, because dust can mean a different thing to, if you ask 100 scientists what's dust, you'd probably get 100 different answers. It does not meet the Parker standard of a scientific expression.
You mean there's dust and then there's asbestos dust?
No,
Is that what you're trying to say?
Putting aside asbestos, just...
Well, no, that's what we're talking about here, right?
The example I was saying is, the dust in question, the plaintiff's expert said, the overwhelming number of studies said was 99% not asbestos dust. It was dirt and road grime and all sorts of other things but asbestos, but there was no quantification of how much dust. In other cases, there are descriptions of billowing dust, of dust on clothing, of breathing it in.
So here's the problem. Your argument seems to say that quantification down to some form of a number is necessary.
Yes,
because, let me finish,
yeah.
and you can respond to it.
Yes, sir.
Just, the reason is because the way I understand the argument, you can correct me if I'm wrong, is that visible dust is seen, the guy's working on brakes, he's working on all these other products that do have some asbestos in it. There's visible dust, and he says he walks through it, and he's walking through it, or that when he's working in the garage, it was generated in the course of his work. You're saying that has to be quantifiable. 99% isn't true. Of course, asbestos exposure to 1% can result in that. And since the only known source of mesothelioma is asbestos, it's a question of where the exposure took place. That's the core of your argument. Does that exposure to visible dust that must have contained asbestos in it in some form, is that required to be quantified? Must we know, to establish specific causation, a number to be able to quantify what percentage of that dust or what percentage of that dust he was exposed to establish specific causation?
Your Honor, I apologize for interrupting.
No, don't worry about that. It's much worse. I've had much worse many other times.
Let me answer directly, but then there's a very specific explanation I want to give. There does not need to be a numerical quantification. You can compare it to some other things where there is an amount known to cause a disease, in this case mesothelioma. There are two particular subtexts to your question that really bear explanation. The first is, this gentleman did have other exposures in a power plant prior to coming here. We don't know what the effect of that was. There was testimony from some that they thought that caused it. But Dr. Moline, their expert witness, describing the very dust that we are now talking about, said she did not know whether the asbestos debris that might have remained in that dust was still biologically active, i.e., whether it had the capability to cause mesothelioma. Your question, in a sense, assumes that the dust must have been able to cause the the disease. But the very expert that they called said, I can't say whether it was still biologically active. How can they have an expert witness to prove causation say, I don't know? It's like in the Parker case, if the expert, Dr. Landrigan in the Parker case has said, I don't know if this particular gasoline that Mr. Parker was exposed to still had benzene in it, because that was what caused the leukemia. And if the expert there didn't even know if the benzene was still present. That's what we get in this case on these facts from their expert. The second point, Judge, is you asked whether there is a known safe level. Parker and Cornell do say.
Well, I actually asked, was there a safe level?
Right.
You know, how much exposure to asbestos can you have and still not get mesothelioma?
There is an answer to that. But the law first. Parker and Cornell both say that it is incumbent on the plaintiff to show what is the level and to show that your exposure is above that level. The experts, all four of the experts, I believe, testified that there is a safe level, and that is the background level. They testified into numbers of fibers. You've heard billions and millions. There was testimony that we all have billions over our lifetime fibers of asbestos in our lungs in our lifetime, that at any given time, if you were to do a long examination of a person off the street, they would have millions of fibers. And the testimony was that at those levels, it is not known to cause mesothelioma. So it's at some level above that, and they have to then say, okay, well, what does the science show? If he was in this garage working and he had an exposure that you would get in a garage, are there studies that show people working in garages are getting mesothelioma from those types of exposures? And they didn't bring forth any such study. I'm not going to go to the epidemiology that pointed the other way, which came out.
What about Roloff's study, though?
The Roloff study had a specific disclaimer at pages 5 and 6. It did find an increased risk for brake workers, but then the authors of that study put a big disclaimer and said, we don't know if this resulted from their exposure from that occupation or from some prior occupation.
Doesn't that go to the weight, then, of their study, rather than whether it's sufficient to show a foundation? In other words, isn't that a jury question?
I don't think it could be when the authors of the study say it doesn't stand for this proposition. But interestingly, Dr. Markowitz didn't rely on the Roloff study for his foundation. He said that we know that chrysotile asbestos at some level can cause mesothelioma, and then he inferred down and said, well, then the 1% debris that may be in brake and clutch dust can cause it. I'll finish up, I see the red light is on. We talked about the OSHA standards. There was no study that showed that exposure to asbestos at the OSHA standards, which were prophylactic, meant to prevent a lot of diseases.
What about your internal memos?
The internal memos never talked about causation of mesothelioma. They simply took the workplace safety rules and advocated them out to the Ford internal community and said, we should abide by these safety rules. There is a discussion about whether it's dangerous, but the internal memos were not a statement by Ford around causation. And there's simply...
I had thought those documents said that Ford was aware of air samples that show that workers who did brake and clutch repairs in particular were exposed to a much greater risk of developing mesothelioma or cancer.
I think if you read them exactly, they do say that from the Mount Sinai study that he referred to, that the exposure levels were higher than Ford initially thought, just counting the fibers. Mm-hmm. But there was no connection then that level of exposure is known to cause mesothelioma. There is a complete absence in the record of any scientific study that shows that.
I could be wrong because God knows you know the record better than I do, but I thought that the Ford documents actually say that they recommended their employees that they stop using compressed air.
Oh, they did.
And of
Absolutely.
course, and this is in the 70s.
Yes, sir.
And this plaintiff was doing the exact same thing 10, 15 years later.
Ford took the recommendations from OSHA to stop using compressed air, to wear masks, at some point to use vacuums. Ford took the cautious approach, and Ford did not put those warnings on its products, and that's the crux of their case. But that is not an admission by Ford that the product was causing the disease. Ford was being prudent. Their position is Ford wasn't prudent enough in extending that warning out to
Could
others.
the jury draw some inference from these internal memos?
Well, they were argued as...
Not favorable to your client, obviously.
I believe it was argued as though Ford had admitted that it knew that its products caused mesothelioma. But again, that doesn't go to the foundational element. Obviously, the jury returned a verdict against Ford Motor Company, and that's why we're here with it being taken away. If the court has no further questions, thank you, Your Honor.
Counsel?
Thank you, Your Honor. Mr. Juni testified, appendix page 501, the asbestos dust was all over the place. Dr. Markowitz relied on the roll-off study, contrary to what counsel said, at appendix page 175 as part of his scientific foundation. Dr. Selikoff, in consultation with Ford, addressed their concerns to a number of asbestos-related diseases, including mesothelioma. Paul Toth, Ford's IH supervisor, went back to Ford and reported this. Ford issued warnings to its own employees, but not to people like Mr. Juni out in the field, well before years and decades before Mr. Juni ceased his exposures to Ford products.
Could you address his representation that I think he said Dr. Molina didn't know if the dust was biologically active?
Dr. Moline didn't have personal knowledge. She wasn't in the municipal garages. She did not know what the state of the asbestos materials was, and for that, instead of having personal knowledge, she testified that she relied on studies of comparable work showing 160 times over the regulatory limit, precisely the kind of work that Mr. Juni was doing. So she had professional expertise knowledge, but not personal knowledge.
And is that methodology accepted in the scientific community?
Yes, there is a scientist brief that was submitted as an amici brief that fully shows that the bottom line is that there is no mainstream scientist in the United States or anywhere in the world who would look at Mr. Juni's occupational record and not attribute his exposures to Ford-related materials as a cause of his mesothelioma. It just would not happen in mainstream science. And the counter theory that only his exposures occurring a few summers as he walked through power plants is the only cause of his mesothelioma would be aberrant and have absolutely no support in the scientific community.
Thank you, counsel.
Thank you, Your Honor.